Right, as South Africa commemorates Human Rights Day, we'll be going to the EFF a little bit later on, their leader addressing Sharpeville commemorations as well. But for now, as South Africa marks Human Rights Day, we take a look at rights in the workplace and what employers have to do to not discriminate. Bongani Masuku from Cliffe Decker Hofmeyer joins me now. Very good afternoon to you. Thanks so much for your time on SABC News. What should employers be thinking about when it comes to ensuring that they don't discriminate against people in the workplace?
Good afternoon, Zinga, and good afternoon to all the viewers all across the country. Thank you for having me. Employers have quite an important obligation in relation to employment equity in the workplace for a number of reasons. First, because of the sorry history that we have as a country and the heritage that we have that has led us to have this day being commemorated as Human Rights Day, but also because of the constitution that we have implemented since 1996, which sets the tone from the top about employment equity and what's supposed to happen in the workplace. So, for example, the constitution gives every person, which includes every employee, by the way, a right to equality. And that right to equality is a substantive right that must be protected and that must be promoted by all persons, including employers. Section 9 creates that right and then requires that there must be enabling legislation that is legislated by the writers of the laws to give content to and to give expression to that right to equality. Section 23 of the Constitution speaks about the right to fair labor practices. Now, two things flow from the constitutional right to equality and the right to fair labor practices. The first is that the Labor Relations Act was enacted as one of those, one of those enabling legislations or pieces of legislation to give content to the right to fair labor practices in Section 23 of the Constitution. The Employment Equity Act is one such act that was also enacted to give content to the right to equality, particularly in relation to the workplace. And these are things that all employers need to be aware of. And these are things that all employers need to be mindful of in their day-to-day dealings with employees, and particularly in the processes and systems and policy frameworks that are in place between employers and employee that regulate the relationship between the two parties. Most importantly, employers must be mindful that in terms of the constitutional rights that I've referred to, as well as the enabling legislation, the Labor Relations Act, the Employment Equity Act, there are obligations to ensure the elimination of all forms of discrimination in the workplace. And this covers all the listed grounds in Section 9, race, equality, gender, religion. One can think here of the LGBTQI community and all the discrimination that certain members of that community suffer, particularly in society, but more particularly as well in the workplace. And these are things that employers must be aware of. There is an obligation on employers to eliminate all forms of discrimination on all of those listed grounds. From the structure of the Labor Relations Act, the Labor Relations Act makes any dismissal or unfair labor practice that is perpetrated through discrimination on any of those listed grounds or on an arbitrary ground to be automatically unfair dismissal. And that puts that type of dismissal on a league of its own in terms of the remedies that the CCMA and the Labour Court can grant persons who are found to have been automatically unfairly dismissed by reason of discrimination. Instead of being entitled to just 12 months or up to 12 months of their monthly salary as at the date of termination of employment, when their dismissal is found to be unfair, those categories of employees are entitled to much more, and that is 24 months of their salaries as at date of dismissal if their dismissal is found to have been automatically unfair. And that is the Labor Relations Act aspect of things. From the Employment Equity Act aspect of things, there's also a right to an obligation for employers to promote the right to equality in the workplace, to eliminate unfair discrimination, to implement employment equity measures to redress the unfair discrimination consequences of our past. There's also a distinction between employers that are designated employers in terms of the Employment Equity Act and employers that are not designated employers. But Chapter 2 of the Employment Equity Act applies to all employers across the board. You may be an employer employing less than 50 persons. You may be an employer that is a private sector employer and not necessarily an owner of state, etc., etc. That all does not matter. You need to be aware that there is an obligation
Mr.
on you to
Masuku,
promote
my
the right to
apologies. We have to break out of this interview. My apologies for interrupting.